Bienenfeld Law with Saul Bienenfeld.
Hi, everyone. This is Saul Bienenfeld, criminal defense attorney. But today we're going to talk about something most people think happens somewhere else. But it's happening right here in the United States. And it's not just a social issue. It's not just a cultural issue. It's a criminal law issue. We're talking about arranged marriage and underage marriage, and how U.S. law, both state and federal, sometimes enables conduct that in other contexts would be prosecuted as a felony. Let's start with the basic truth. If an adult has sex with a 14-year-old, in almost every state, that's statutory rape. No consent defense. The law treats minors as legally incapable of consenting to sexual contact with adults. But here's the kicker. If that same adult marries the 14-year-old, the conduct may suddenly become legal. Why? Because in many states, marriage creates an exception to statutory rape laws. The criminal statute literally carves out a defense, unless married to the victim. From a criminal law standpoint, that's extraordinary. We're talking about the same act, the same age difference, the same people, the same imbalance of power, but the presence of a marriage certificate flips the legal switch from felony to lawful. As a defense lawyer, I've seen laws with loopholes, but this isn't just a loophole. It's an escape hatch. At the federal level, the contradictions get worse. The federal criminal code prohibits sexual conduct with children between the ages of 12 and 15, unless the parties are married. And immigration law? There's no minimum age for a U.S. citizen to petition for a foreign spouse or fiancé, and no minimum age for the beneficiary. That means child marriage can be, and has been, used as a legal vehicle for trafficking. Between 2007 and 2017, the U.S. approved almost 9,000 spousal or fiancé petitions involving a minor. In 95% of those cases, the minor was a girl. From a criminal defense perspective, that's the government granting a legal status that would otherwise shield an adult from sex crime prosecution. Between 2000 and 2018, nearly 300,000 minors were legally married in this country. About 86% were girls, most to adult men. In over 60,000 of those marriages, the age gap met the legal definition of statutory rape. But prosecutions didn't happen because the law said, well, they're married. That's the kind of fact pattern that in any other setting would put someone in the defendant's chair. Instead, it's putting them in the wedding aisle. As of right now, only 16 states and District of Columbia have banned all marriage under 18 without exceptions. In others, including California, Mississippi, and Oklahoma, there's no statutory minimum age if you have parental or judicial consent. And here's what I find troubling as a lawyer. When a judge approves an underage marriage, that judge is effectively authorizing conduct that the legislature in the same state has criminalized for everyone else. The criminal law is supposed to protect people who can't protect themselves, including minors who lack capacity to give informed consent. In theory, marriage shouldn't override that protection. But in practice, underage marriage often means consent is presumed, even when it shouldn't be. And remember, in many arranged marriages, the minor's ability to refuse is compromised by cultural pressure, family authority, or outright coercion. That takes it out of the realm of arranged and into forced, which under international law is considered a human rights violation. And here's something most people don't think about. Underage marriage can still end up in criminal court, and not always in the way you'd expect. Domestic violence cases. Once the relationship turns abusive, prosecutors still have to decide whether to pursue charges, and they often run into evidentiary and consent challenges. Protective orders. Judges are reluctant to issue them when they would dismantle a legally recognized marriage. Immigration fraud charges. If the marriage is suspected to be a sham for immigration purposes, both parties can face felony counts. So from my perspective as a defense attorney, these cases live in a weird legal gray zone, part family law, part criminal law, part immigration law, with plenty of room for injustice on both sides. If I were writing the statute books, I'd start with a federal minimum marriage age of 18, no exceptions. elimination of the marriage exemption to statutory rape laws, better judicial training on coercion and consent so arranged doesn't slide into forced. Because if we're serious about protecting minors, the law can't keep giving people a marriage certificate as a get-out-of-jail-free card. So the next time you hear arranged marriage or child marriage, don't think of it as a faraway issue. Think about it in terms of your own state's penal code. Think about how the same conduct that's criminal on Friday becomes lawful on Saturday because of a marriage license. As a criminal defense attorney, I believe in protecting rights, but I also believe in consistent laws. And right now, our system sends a very dangerous message that you can legalize what would otherwise be a sex crime by simply saying, I do. I'm Saul Bienenfeld, and that's today's reality check. Stay informed, stay critical, and I'll see you next time.